Good afternoon, and thank you for joining us today as we discuss estate planning versus guardianships. Just to get started, as you know, we are Burner Prudenti Law. My name is Britt Burner. I'm one of the partners, and we practice in the areas of elder law, estate planning, trusts and estates, and real estate. And if you would like further information about our practice areas, either ones discussed today or other practice areas, please visit our website at burnerlaw.com. We have prior webinars like these, as well as blog posts with more information. If you have any questions, please put them in the Q&A on the bottom of your screen. You'll see there's a button that says Q&A. You can type it in there, and I'll take questions at the end. Okay, so let's get started. So first, I'm going to talk about estate planning, because the goal here is to do effective estate planning so that we don't end up in guardianship. And so when we talk about estate planning versus guardianship, what we're really talking about is getting the proper planning done in advance so that you don't end up in a situation where you are the subject of a guardianship, where your life is under the scrutiny of the courts. And that's what we're going to be discussing today. So first of all, the first document I want to discuss is the power of attorney document. This document is vital if you want to avoid guardianship should you become incapacitated. Why? Well, anything that requires a signature by you, your authorization, access to a bank account, etc., requires another person to have the legal authority over that issue. So let's take very simply a checking account. If you have a checking account with just your name on it, you are the only owner of that checking account, and you become incapacitated and you don't have the ability anymore to manage your finances, to pay your bills, etc., then there's nobody else who has the legal authority to do so on your behalf. Even a spouse does not have the authority to access your money without legal authorization. Now, many times a spouse might be joint on the account, or you have a child who's joint with you, but they do not have the right to do anything if you are the only person on that account. Similarly, you'll often have an issue if you need to enter into a contract, perhaps a contract to hire someone to assist you, to hire a home care agency, to move to an assisted living or other type of community. If you need to have a contract signed on your behalf, same thing, you will need to have somebody with legal authority to do so. And so that's what a power of attorney is going to do. I want to make it very clear, not all powers of attorney are created equal, right? So a power of attorney document lists exactly what powers someone else has over your assets or your affairs. So if you only give limited powers, say to access a bank account, but you don't give any other powers, then your agent won't have the ability to access, to do those things on your behalf. So you want to be really careful and really thoughtful about what powers you're giving to another person or persons in this power of attorney document. That power of attorney document has to be signed by you in front of a notary and a witness. The document requires 2 witnesses, but the notary can be one of the 2 witnesses in addition to notarizing your signature. Then the person you're naming is called the agent. You're the principal and you're naming an agent. The agent that you're naming to act on your behalf will also need to sign that document in front of a notary and have their signature notarized in order to be able to use that document. So let's again take that example of the checking account. If you have a checking account and you sign the power of attorney document and you sign it in front of a notary, your signature's notarized, witnessed, and then you give it to your agent who similarly has their signature notarized on the document. You then have to give that signed and notarized document over to the institution that you're looking to accept it. So in my example, it's your bank that holds your checking account. They then send it to their legal team, who reviews the document for its validity to make sure that everything is okay with the document, that it is legally valid and doesn't have any defects. And then once they accept it, the power of attorney is on file, and your agent now has the right to act on your behalf with regard to that account. Now, your agent has to do according to your wishes and your direction if you have mental capacity. So you don't lose all control, and you're still able to do for yourself with a power of attorney. But that power of attorney document does need to be officially accepted by the institution that you want to acknowledge this authority in another person. So you can be giving very broad powers to another individual, especially if you're worried about your incapacity and who's going to handle things for you should you become incapacitated. You want that power of attorney document to cover enough items and enough circumstances that your agent doesn't end up in a situation where they have to seek guardianship because there's a power that they don't have. So you want to make sure that this document does what it needs to do in the future. But at the same time, because you're giving such broad powers to another individual over your life, over your assets and your business affairs, you want to make sure that you're choosing the right person to serve as your power of attorney. Is it someone you trust? Is it someone who you believe that if you become incapacitated, or even if you're not incapacitated, that they're going to do what's in your best interest and follow your instruction? So you want to make sure you're choosing the right person, a trustworthy person. Now, you'll notice on a lot of power of attorney documents, there's something called a monitor. You can designate a monitor. Now, we don't often do this. However, it is possible, especially if you're naming someone who you might want to have some oversight. If you're not naming a family member, maybe I had a situation where somebody was naming an accountant to serve as their power of attorney. So they wanted a monitor who could always check in should it become necessary on that agent under the power of attorney. You can name a monitor. Most often, when we have family members serving as agent under the power of attorney, we don't have a monitor overseeing them. But in certain circumstances, it might make sense. You can also designate a successor agent. So let's say I have one person serving as my agent. Should that person become unavailable to act, I want to make sure there's a successor in place, because I might be in a position when they become unable to act where I can't sign a new power of attorney document. And so we want to make sure that we have a successor in place. Now, on a power of attorney, you can name more than one person to act at once. So if you have two children, for example, and you want to name them both as your power of attorney, you can do so. And we usually recommend that you allow them to act independently of each other and that you initial that they can act separately, because what we're finding is that a lot of institutions are unwilling to accept accounts that have joint agents that have to act together. My understanding is that they do so because they think it's very hard to police an account like that to make sure that both agents are on board with all of the actions being taken. Again, this goes back to who you're naming. And if you are naming multiple people, are they okay to act together? Do they get along? Are they going to fight just for the sake of fighting? Well, then they might not be the best two people to be naming as agent under the power of attorney. And similarly with your successor or successors, you can name multiple. Now, often in the power of attorney document, we'll also put in a modification, a specific power that deals with the nomination of a guardian. And it says, should a guardian become necessary to handle my affairs, I would choose that the person named as agent in this document serves as that guardian. Now, the nomination of guardian can be done as a power in the modification section of the power of attorney document, but it can also be a separate document that you sign and have notarized. And then that's indicative in the future, should you become the subject of a guardianship, that you have an idea of who you would want to serve as your guardian if that becomes necessary. So again, it's usually a power we put into the power of attorney document, and it can be its own document on the side. Now, when I talk about the modification section of the power of attorney, what I'm referring to is that there are very standard powers that you've all seen in a power of attorney document, the A through O powers. Very often people will initial at letter P, giving all of the above listed powers. And that includes banking transactions, insurance transactions, etc., real estate transactions. But there's another section in the document that refers to modifications. And modifications are any other power that we choose to add into the document. Now, very often as elder law attorneys, when we're worried about somebody becoming incapacitated, we're worried about the powers and the items that might need to be handled for them in the future. There are other powers we put into that modification section. That might include accessing a safe deposit box, applying for government benefits. It could involve gifting. And there's a special place for you to put that your agent is allowed to gift assets. Gifting can include not just what you think of as gifting, as giving money to another person or to a charity, but gifting could also include putting assets into a trust for your benefit or the benefit of one of your other loved ones or beneficiaries. And so you want to make sure, again, that whatever powers might be necessary in the future, should you need any Medicaid benefits or tax planning, if you become incapacitated, that's in the document and that the person you've named has those powers and that you trust them to exercise them properly. There was a change in the power of attorney law in 2021. On June 13th of 2021, a new power of attorney form and laws that went along with it went into play. Prior to that date, if you signed a power of attorney, it is still a valid power of attorney today if it was a valid power of attorney then. So you don't have to worry that if you or a loved one have a power of attorney from before June of 2021, that it's invalid. It will be valid if it was valid then. However, that being said, especially if you have a document that's much older, you want to make sure that with this change of law, that it's a good idea to take a look at that document and make sure that it still follows your wishes, that the agent that you've named is still an appropriate agent, and that the powers that you've given to that individual or individuals are still the appropriate powers and there's nothing missing. So a change in the law is a really good opportunity to remind us to review our documents. And while I'm talking about reviewing documents, I do want to note that a change in the law, a change in your personal circumstances, including birth, death, perhaps a change in relationship, retirement, all of these things are a good reason to re-evaluate your estate planning documents and to make sure that they are still suiting your goals with your change in situation. And very often it will be upon the review at one of these life events or a change of law event that somebody will realize that maybe things are not exactly the same as when they originally signed the documents and that there's some tweaks or changes to be made. Similarly, it might just be that when you review those documents, you say, nope, these powers are still appropriate. This is still who I would want to name. And even with this life event or this change of law event, my wishes are still carried out by this document. But it's a good reminder. Now, if you don't have one of those events or there's not an appropriate change in the law, we usually say that you should review your documents every 3 to 5 years to make sure, again, that they're still following your wishes. I can't tell you the number of times that someone will come in and they'll be in their 60s and their children will be in their 30s and they'll say that they hadn't looked at their documents since their child was born. Well, that's a very long time. A lot happens in 30-something years. And so we want to make sure that the documents are appropriate with each stage of your life. Because what is appropriate for you when you're in your 20s or 30s with very young children or a baby might be very different than what you might want when you're in your 60s or 70s, not to mention the changes in law that likely happened during that time. It's also likely that your assets change during that time, so what you need might be a little bit different. In addition to the power of attorney document, you want to make sure that you have a healthcare proxy. A healthcare proxy says who makes medical decisions for you if you're deemed incapacitated by a doctor and cannot make them for yourself. So a healthcare proxy document has to name one person at a time. It's only in effect if you become incapacitated, and that person's address and phone number is listed on the document so they can be contacted should they need to be in order to make decisions about your medical health. Once you're incapacitated, that agent under the healthcare proxy, once that document is in effect, also allows that individual to receive your medical records because there's HIPAA, healthcare privacy, which is the law that says that we have privacy over our healthcare information. And so by your agent under the healthcare proxy, by you being deemed incapacitated and that person stepping up to the plate, they also have access to your healthcare information. If you want that individual to have healthcare information prior to you becoming incapacitated, you can sign what's called a HIPAA release form, which allows for medical information to be released to that individual or any individuals, even though you're not incapacitated at any point in time. Unlike the power of attorney document, a healthcare proxy only requires 2 witnesses over the age of 18 who are not a party to the document. It does not require a notary. So you don't need to have the healthcare proxy notarized. It can be signed by any 2 people that are over the age of 18. And so very often they're signed when you check into a hospital if you don't have one to provide, and any 2 witnesses there can be your witnesses. The witnesses have to sign their name, print their name, and put their addresses and the date that they witnessed you signing the document. They have to actually witness you signing the document is the only requirement. The other document I want to refer to is a trust. Now, we could talk about all sorts of trusts: revocable, irrevocable for Medicaid asset protection purposes, irrevocable for estate tax planning purposes. But without getting into the details today, because that could take up a whole other hour or 2, I just want to say that a trust is a legal document that, just like a last will and testament, says what your wishes are for after your death as to how your property should be distributed, but it can also provide for what should happen during your incapacity and while you have capacity. And so a trust document can often be in place to stop a guardianship from taking over because you've put your assets into the trust. So the trust is a living, breathing thing that owns things while you're still living. And that trust can say who's in charge of the items in that trust's name. So let's take the deed to a house. If I own a home and I want my trust to own my home, I'll sign a new deed giving my property to my trust. If it's a revocable trust, I might very well be my own trustee and manage and control it myself. But should I become incapacitated, my trust can say who takes over for me, similar to what a power of attorney might do, but just of those trust assets. And then also, if upon my death, who's in charge. Now, my trust can also say that if I become incapacitated, it can direct how I want my money to be used. Maybe once I'm incapacitated, I don't want charitable gifts to be made, or maybe I would want my agent to continue gifts that I had already been making. So the trust can say that, and the trustee can follow those wishes. You might also want the trust to say that should you become incapacitated, that anyone who is dependent upon you, a legal dependent, or your spouse can also be provided for, and the money in the trust could be used to benefit that person. So it all depends on your situation, and that's how we write out the trust document to cover these issues. So you can see that if you have a trust, and that's how your assets are to be dealt with during your incapacity, and if you have a power of attorney that directs how things should be handled during your incapacity, then in that case, you shouldn't need a guardianship in order to determine who's going to handle these affairs for you. It should be laid out in your estate planning documents. So again, when we talk about estate planning versus guardianship, it's because many guardianships can be kept away or can be prevented by having proper estate planning documents. Now, there are circumstances where someone has proper estate planning documents, but there's enough issues that come up that a guardianship is still necessary. And I'm going to talk about some of those things now. Now, first and foremost, I want to say that in New York, a guardianship is the term that we use. We don't use the term conservatorship like other states do. So you might see that if you're doing some research. Now, a guardianship could be a guardian of the person, meaning healthcare decisions, social decisions, who can visit, travel, where somebody's living, place of abode. Those are a guardian of the person who determines those items. Whereas a guardian of the property is someone who's in charge of financial property. But it's important to remember that a guardianship is under the mental hygiene law, Article 81 in New York State. That's the type of guardianship I'm referring to today. That guardianship is meant to be the least restrictive alternative. So what that means is the guardian should only be given by the court the powers that they need in order to help the individual who's the subject of the guardianship, the incapacitated person or the person in need of a guardian. The person who is a guardian is being granted for them, that person needs to have as much autonomy as they can have given their circumstances. And the court tries to protect that person's autonomy and that person's right to handle for themselves what they can. Now, some people can't handle anything for themselves because they truly are so incapacitated that that's all just too difficult, in which case very expansive powers might be granted. But again, the goal is for the least restrictive alternative. Now, I use two terms, incapacitated person and person in need of a guardian. Now, an incapacitated person is a person who, after this guardianship process, is deemed incapacitated by the court. They are found that they have functional limitations and they don't understand or appreciate the nature and the consequences of those inabilities to handle things on their own. And as a result, they need someone to be appointed to handle those items for them. And that's when someone has an incapacity. Now, in many cases, we have what's called a person in need of a guardian, which is someone who does not necessarily have zero capacity, but maybe is someone who can do some things on their own. Now, a person in need of a guardian is someone who has consented to the guardianship. So we know at the very least, they have the mental capacity to consent to somebody being their guardian. But when you consent to someone being your guardian, you also have a level of capacity where you're probably not having completely broad powers because there are things that you can do on your own. And so at the end of the guardianship proceeding, that's the determination that's also often made. But again, in order to be a person in need of a guardian, or we use the term PING, you need to be an individual who has enough capacity, according to the court, to consent to that guardianship. Now, when do we do a guardianship? So like I said, if you have no estate planning documents and you lack the ability to handle things on your own, a guardianship might be brought by someone else, a family member, might be if you're in the hospital and you can't plan your own discharge to get safely home or figure out where you're going to go next, the hospital might bring it. In certain circumstances, your local municipality, your county, your city might bring a guardianship on your behalf if there is an issue and it's come to their attention that you can't handle your own affairs. Anyone who is looking out for you and notices this inability can bring a guardianship. So if you don't have any documents, then you're right for a guardianship if you do have this incapacity. Now, I will say, if someone brings a guardianship and you can prove, one, that you have capacity, or two, that you have a competent power of attorney, trustee, healthcare proxy, and all your needs are taken care of by this surrogate that you have yourself appointed, well, then a guardianship will be dismissed because you have prepared for this issue. So that's again why that proper estate planning can be a defense should someone bring a guardianship. Let's say you have two children and you get along with one and not the other. And the one you don't get along with says, my mom's incapacitated, she needs a guardian appointed, but you've already signed a power of attorney and healthcare proxy naming the other child. The other child's done nothing wrong and they're doing a perfectly fine job. Well, the child that you're not getting along with, you brought the guardianship, is unlikely to win in that case if it's that clear cut that the other individual is doing the right job because you picked someone and you did the proper documentation and there aren't functional limitations that can't be filled by that other person. Again, because guardianship is the least restrictive alternative. So if the least restrictive alternative is that you don't have a guardian and that you're properly cared for with these other documents that you've signed in advance, then we don't have to worry about a guardianship. Another time we bring a guardianship is if somebody signed these documents, but there's not enough powers. I've had a lot of circumstances where someone signed a power of attorney a long time ago, and there's certain powers to transfer assets out of someone's name or do a certain planning, and those powers are not listed in the power of attorney document. Well, then it might just be the person who's named in the power of attorney who's asking the court for these additional powers. And that could be for a short period of time, or it could be for an indefinite duration. The court can make that determination. So that's another time we often bring a guardianship, is if there are not enough powers in the document. Misfeasance. So let's say that somebody just doesn't act, right? You have a power of attorney document, you've signed it, you've named an agent, but that agent isn't helping. They're not doing anything. Often this will happen if the agent is in a situation where they're not helping you get discharged from a facility, or they're not helping you apply for Medicaid to cover the cost of the facility. Well, then the facility might find that there's essentially, even though you've signed this document naming someone, there's no one acting. And so it's as if you have no one. And so that could be a reason to bring a guardianship. Also, malfeasance. If the person you've named under the power of attorney isn't doing the right thing, if they're, let's be very dramatic, if they're stealing from you, if they're not doing what's in your best interest and they're not properly providing for you because they're acting in their own best interest, sometimes that malfeasance, that misuse of funds, that stealing, is a reason that another person might bring a guardianship and say, we need to get rid of this power of attorney because they're not doing what's right here. We have a problem. And the court can set aside the power of attorney document in that case. As I said, it's the least restrictive alternative. So we've all seen these terrible movies where people don't have due process, they don't know a guardianship's being brought for them, and then all of a sudden someone else is in charge of everything for them. Well, that's not generally how guardianship is going to go. It's certainly not how it will go here in New York State. So in New York State, we have a law, the Mental Hygiene Law, Article 81. That's the type of guardianship I'm referring to today. And under that law, it states the requirements for how to properly bring a guardianship, who's required to get notice, and how the procedure will go. So I'm going to go through that now. So it starts with a petition for guardianship. So let's make it very simple here. We have an individual, maybe they had a medical incident and they are not conscious and or able to speak, certainly not able to sign documents. They've done no estate planning and they are in a facility and nothing can be done in terms of getting Medicaid to cover the cost of their care. No one has access to the funds to privately pay for the cost of the care. And there's no one who can sign off on anything because that person didn't sign any documents, right? So we're not assuming wrongdoing or anything. There's just nobody to help. There's no one with legal authority. Well, then a friend or family member, or if there is no one, perhaps the facility, will bring a petition for guardianship. That petition gets submitted to the court. It hopefully will have as much information as the petitioner, whomever it is, has about that individual. So sometimes we can be very detailed, right? My mom, this is her case, this is her medical situation, this is why she can't handle her own affairs. I know what her assets are, these are what they are, but I can't access them because I don't have legal authority. So I'm asking the court to appoint me and to give me the power to access those funds. Maybe I ask for some powers to do some Medicaid planning, maybe not. Maybe I just need to access the funds so that I can pay for the costs of her care, so I can make decisions about her care. And I ask for those specific powers in my guardianship petition. That gets filed with the court. It gets assigned to a judge in the county in which mom resides, or it's in at the time that the petition is filed, and there's differences in how and where we file. And then a judge is assigned and reviews the petition. And if the judge finds there's enough information in the petition that there's likely a problem here, the judge will sign what's called an order to show cause that sets a hearing date, usually 28 days out, where this case will be heard. And evidence will be put on the record to determine if this person is incapacitated. It will determine who should be named as the guardian and what powers that guardian should have. That order to show cause will not just set a date and a time for the hearing, it will also appoint what's called a court evaluator. This is often called the eyes and ears of the court. This is an individual who will do an investigation. They will try and meet with mom in this circumstance and see if she really is incapacitated. They'll meet with petitioner daughter. If there's other family members, they'll meet with the other family members. If mom has siblings, they're entitled to notice that the proceeding has been brought. Perhaps a social worker at the facility, anyone else who can give information to the court to help make this big determination. And then the court evaluator writes a written report and also testifies on the record at that hearing as to their findings. And they are subject to cross-examination. So if there's a belief by one of the parties, if there's a fight between two family members as who should be guardian, they have a right to cross-examine the court evaluator about the items in their report. Sometimes the order to show cause will also appoint a lawyer to represent mom. So to be mom's mouthpiece. Now, let's say mom's not totally incapacitated. Let's say she has a mental incapacity, but she's verbal. She's not unconscious. She's able to say what she wants, except she doesn't have, she has dementia or Alzheimer's, and she's unable to understand what's going on. And so when she says what she wants, it doesn't make that much sense, right? She says, I want to go home, but she doesn't have the money or financially, or it's unsafe, or whatever the reasons are, whatever it is, mom is not understanding any limitations or how to set this up for herself and really is incapacitated. The court might appoint a lawyer so that mom has a mouthpiece to voice her opinions. That lawyer's job is not to do what they think is in mom's best interest. That lawyer's job is to take mom's position. So whatever it is that mom wants, that's what this lawyer is fighting for. And sometimes it's not necessarily that easy for that individual, right? Because they might not think that what mom's saying makes sense, but mom has a right to counsel and mom has the right to be heard. And so often that court-appointed counsel will be appointed to represent mom's best interests. In addition to the court evaluator, who doesn't represent anyone's interest, who is just an investigator, eyes and ears of the court to report back to the judge so that this can be done pretty quickly without days and days of testimony. Then the court evaluator will do their entire investigation, submit their report, and then the hearing day comes. If it's an uncontested hearing, then the petitioner just has to put on the record proof and evidence that it does lack capacity and that they are an appropriate person to be named as guardian, and proof as to why they need the certain powers being requested. The court evaluator can then testify. If anyone else has cross-petitioned, then they can put on their case. If there's nobody contesting this and everybody's in agreement, that mom is incapacitated, then the court can say that mom's incapacitated, can appoint the guardian, and then an order and judgment will eventually be put together and signed, giving that person the power to make decisions. Now that's when no one's fighting, right? That's when things are pretty cut and dry, mom's incapacitated, and nobody's fighting over what should happen. Obviously, based on all the things I've said, you can see there's other circumstances where it becomes a much bigger issue, right? There's two family members who are fighting over who should be guardian for mom, or they're fighting, they don't think that their sibling is the appropriate person to be guardian, but they themselves don't want to be guardian. Or maybe they think that the sibling has a power of attorney and that they're stealing. And so sometimes there has to be documentary evidence of that. And so these can get much bigger than that simple situation. But again, if someone has that proper estate planning in place, in order for the court to set those estate planning documents aside, there really has to be proof that the person who's named has done something to harm the individual. Because just disagreeing with how your sibling is handling things for mom without it being harmful to mom is not going to be enough for the court to say, I'm going to set aside the wishes that mom had about who would be serving as her agent. I'm going to set those aside and name someone else's guardian. You can't bring a guardianship for those reasons. The court's not going to want to do that because mom has the right and had the right when she had capacity to choose who that person would be. Now, very often, obviously, we've already talked about a petitioner who has an attorney. We've talked about a court evaluator, perhaps a court-appointed attorney for mom, and maybe attorneys for any other persons who are involved. Now, in many situations, the fees will be ordered by the court to come out of mom's money, as long as it was seen to be a proceeding that was properly brought on mom's behalf for her best interest, then the court can award those fees to be paid out of mom's money. However, if I bring a guardianship and the courts found that it was frivolous, that I shouldn't have brought the guardianship, that there was no reason, I could be assessed with the fees. And so sometimes there's a complicated issue about who's paying the fees in a guardianship. So when you enter into a guardianship or you decide that you're going to bring a guardianship for another person, you really want to think about the likelihood of your success and all of the issues involved, because you don't likely want to end up in a situation where you're stuck with these enormous fees and you didn't get the relief that you were looking for. So that's part of the decision making as to whether or not to bring the guardianship. You also, if you're not successful in bringing the guardianship, and let's say you bring a guardianship and the court doesn't find that mom's incapacitated, you also run the risk that you've really upset mom, right? Because mom got in the mail or actually personally delivered to her, personally served to her, this order to show cause and petition that said all the reasons why you think she's incapacitated. So you really want to make sure that you're doing this with good intentions and for the right reasons, because there's a lot of consequences if it doesn't go right. And you want to make sure that you're only doing this in the best interest of another individual and only if they really need it. Again, because I'll say it a million times, we're looking here for the least restrictive alternative. So if the least restrictive alternative is no guardian at all, the petitioner could be in a very bad position. Now, once a guardian is appointed, remember, they only have the specific powers in the guardianship document, the powers over the property and the person, depending on what those powers were that were given. Now, if a guardian needs additional powers, they want to do additional planning or move the individual to another assisted living or another state or another county, you need to go back to the court and ask for permission to do so. So a guardian doesn't just act as they want, they have to go back to the court and ask for permission to do things. So you also want to make sure that if you are a guardian for someone, that you make sure you're continually going back to the court. Also, as a guardian, you have to do an accounting to the court every May. So first there's a 90-day report, which is an initial report, 90 days after being commissioned as guardian. You have to tell the court what you've done in those 90 days. And then every May you'll submit an accounting. Now that's not just an accounting of the money. Yes, you have to show every dime that came in and every penny that came in and every penny that went out and where it went and what you did with it. But you also have to, if you are the guardian of the person, you also have to answer certain questions about whether that individual went to the doctor and what was the last time, and if they have any additional diagnoses. So it's not something that happens without any oversight. A guardian does have continued court oversight. Again, you can see as I go on and explain the complexities of a guardianship, you can see the reason why if we can avoid guardianship with proper estate planning, it's much more time effective, it's much more financially cost effective, because you're not continually going back to the court for permission to do things if you're the agent, if you're the guardian, and you're also not in a situation, which by the way, every time you go back to the court, those are fees, right? Because the court could reappoint a court evaluator, they could reappoint an attorney for mom. There's all sorts of things that could happen, and you could be paying your own attorney to make these applications to the court. And then you also have the work of this annual accounting. So again, if we can avoid guardianship, we like to, because it's intrusive, because you're adding the courts into your life. And we often want to avoid adding the courts into life. Now, that being said, we do end up in situations where even with the proper estate planning documents and even with everything being handled in advance, there still can be issues with how an agent handles the affairs of someone. And we can end up in very long, drawn-out guardianship proceedings where the court really takes seriously how mom or dad or whomever the individual is being cared for and making sure that they are safe. Because once a court hears that there's some issues going on, or that someone is being mistreated or their funds are being misused, the court generally doesn't want to just let that go, right? They want to investigate it. They want to make sure that people are being properly treated, especially if they're incapacitated and they can't stick up for themselves. So again, in conclusion, you have estate planning, which very hopefully keeps you out of a guardianship court. But should you not have the proper estate planning, or it doesn't go as you wanted because of the individuals you've named, or the documents don't suffice, don't do all the things you need it to do, someone may end up in a guardianship situation. And you want to make sure that if you are petitioning to be someone's guardian, that you're aware of all the pros and cons of bringing the proceeding and all of the work required as guardian in the future, because it's a lot of work to be a guardian. It's a big responsibility because you are court appointed to act a certain way and court appointed to do certain things. And so you really want to make sure that you're being advised properly about what this all means when deciding if you should even bring that guardianship proceeding. So I'm going to pause now to see if there's any questions, and feel free to write them in the Q&A box at the bottom. But if you have to leave, I'd like to thank you for joining us today. There's a lot of information about this on our website, again, burnerlaw.com, in the blog section. And we hope that you join us for future webinars to learn more about estate planning, elder law, trust and estates, and real estate topics. So now we'll go to the questions. A question is that there's a power of attorney with only a notary and no witnesses. Is it okay to use the document? If that document was signed after, it depends on when the document was signed, because there were changes in the law over time. So I would say that if that document was signed after June 13th of 2021, then no, that's not okay. After June 13th, it required 2 witnesses, one of which could be the notary, but 2 witnesses and the notary. Prior to that date, two witnesses were only required if you had what's called a statutory gifts rider, which again could be a very important part of the document. So if your document was signed before 2021 and you don't have a statutory gifts rider, I would recommend meeting with an attorney or going back to your attorney to see if that's something that might benefit you in the future. I'm not saying that everybody needs it or wants it, but it's certainly something you should become educated about with your documents. Thank you for the question. Okay, I think that's all. Well, thank you again for joining us today. I hope that you all have a great rest of your day, and we'll see you soon. Bye.